She didn't report him. She didn't call a lawyer. She didn't go to the department chair, the dean, or the student affairs office. She wrote one email, and when he read it, he cleared his desk and walked out of the university for the last time. But that's not where this story ends. That's not even close to where the story ends. Because the email was only the beginning of what Adizio Okonkwo had been quietly, methodically building for 3 years. And by the time the people in that hearing room understood what she had actually done, not just to the professor, not just to the university, but to a system that had been running the same play against people like her for decades, there was a federal judge sitting across from her who had stopped speaking entirely. Not because he was angry, because he was ashamed. This is the story of a woman who was handed the worst possible version of her life and used it to take apart the machinery that built it. This is the story of what happens when someone who knows the law better than the people weaponizing it decides finally to stop being quiet about what she knows. My name is not important. What matters is that I'm going to tell you exactly what Adiz did, exactly what it cost her, and exactly what it changed. And by the end of this, I want you to think about something very specific. I want you to think about the moment in your own life when you knew something that the powerful people in the room didn't know you knew, and what you did with that knowledge. Because Adiz made a choice with hers, and it was not the choice anyone expected. To understand what Adiz did, you have to understand what she was before any of this happened to her. She was not a woman who had stumbled into immigration law. She had been pulled toward it the way some people are pulled toward water. Not by choice exactly, but by something deeper than choice, something that feels like recognition. She had arrived in the United States from Lagos at 19 on a student visa, carrying 2 suitcases, a full academic scholarship to a university in Ohio she had never seen except in photographs, and the specific kind of confidence that comes not from never having been afraid, but from having been afraid so many times that fear had stopped feeling like information. Her mother had pressed a folded piece of paper into her hand at the airport. On it was written a single sentence in Igbo. Adiz would not translate it for years. When she finally did, in an interview much later, she said it meant something close to, "Do not let them make you small by degrees." She didn't. She finished her undergraduate degree in 3 years. She took the LSAT on a Tuesday and scored in the 98th percentile. She enrolled in law school at 22, graduated at 25, passed the bar on her first attempt, and opened a solo immigration practice in Columbus, Ohio at 27 with 11 clients, a shared office space, and a reputation that was already traveling faster than her business cards. She was exceptional. She knew it. She did not perform not knowing it. This matters because the people who would later come after her needed her to be arrogant. They needed the story of her downfall to feel deserved, and she did not give them that. She gave them something much harder to work with, someone who was excellent and knew it and was kind anyway, thorough always, and never, not once, less than completely prepared. Her clients were the people the system was not designed to hold. Farm workers, domestic workers, people who had been in the country for 15 years and were one administrative error away from losing everything. People whose children were born here and whose parents were being removed. She worked a 60-hour week as a standard. She charged on a sliding scale. She kept meticulous records. She won cases that other attorneys had declared unwinnable, not through drama or argument tricks, but through the specific superpower of having read every relevant precedent, every procedural rule, every footnote in every filing that touched her client's case. She was, in the language of her profession, extremely dangerous to the people she was opposing, which is why, when they finally came for her, they came for her the way powerful institutions come for people they cannot beat directly. They came for her paperwork. It started with a complaint, a single complaint filed anonymously with the Ohio State Bar Association, alleging that Adiz Okonkwo had engaged in unauthorized practice of law. The claim was specific. It alleged that at the time she sat for the Ohio bar, her student visa had lapsed for 11 days during a processing delay in her visa renewal application. 11 days, during which the complaint alleged she had technically been out of status, during which the complaint further alleged she had continued to attend law school, had taken a practice exam, Wifwin had met briefly with a law clinic client. 11 days. Years ago, in circumstances that even the immigration court she appeared in regularly would have classified as an administrative oversight, not a violation. A lapse so minor that it would have been resolved with a form and a processing fee. A lapse that had, in fact, been resolved, documented, reported, corrected, before she had even taken the bar exam. She had the paperwork. Of course she had the paperwork. But the complaint had been filed, and the complaint had been filed at a very specific moment, 3 weeks before the scheduled hearing in the case of Flores versus Department of Homeland Security, a case that Adaz was on the verge of winning, a case whose resolution would set a precedent affecting the deportation status of several thousand people in the Midwest, a case that certain parties had a significant financial and political interest in losing. The timing was not a coincidence. Adaz knew it was not a coincidence. The question was whether she could prove it before the Bar Association's disciplinary process stripped her license and made the entire question irrelevant. The presiding officer at her disbarment hearing was a man named Gerald Whitmore. He had served on the Ohio Board of Professional Conduct for 11 years. He was 63. He had a reputation for being fair, for being methodical, and for not being particularly interested in the political pressure that occasionally arrived in the margins of his cases. He was, by most accounts, a good man doing a difficult job. He was also, on the morning of Adaz Okonkwo's hearing, a man who had been briefed by people above his pay grade on the preferred outcome of the proceeding. He would not have described it that way. He would have said he had received context. He would have said he understood the broader picture. He would have said he was simply aware of certain considerations. Adaz would have called it what it was. She walked into that hearing room on a Tuesday morning in November, wearing a dark blue suit she had bought for her first bar appearance and had worn to every significant professional moment since. She carried one folder. Inside the folder was a 17-page document she had spent 14 months preparing. She also carried a legal pad. On the legal pad, she had written 4 words at the top of the first page. She had underlined them twice. They don't know yet. She sat down. Once she arranged her folder and her legal pad in front of her. She folded her hands and she waited. The hearing opened the way these hearings open. Procedural recitations. The reading of charges. A representative from the Bar Association presented the complaint with the practiced efficiency of someone who had done this many times and expected to do it many more. The substance of the allegation was laid out. The 11-day lapse. The technical out-of-status period. The assertion that her bar admission had therefore been improperly obtained. Adaz listened. She took no notes. She did not look at the folder. Whitmore watched her not look at the folder. When it was her turn to respond, she stood. She acknowledged the timeline of the visa lapse. She confirmed that the lapse had occurred. She submitted into the record, when the documentation of its resolution, the Form 539, the approval notice, the dated correspondence with USCIS, the certification from her law school's International Student Office confirming that the matter had been reported and resolved prior to her bar examination. Then she sat down. Whitmore looked at the documentation. He looked at Adaz. He said, and this is documented in the hearing transcript, Ms. Okonkwo, this documentation appears to address the timing concern. The board has, however, received information suggesting that the nature of your visa status during the lapse period may constitute a more fundamental bar to your admission than a simple administrative correction would resolve. Adaz said, I understand the board's position. She did not say anything else. Whitmore waited. When nothing further came, he continued. He outlined what he called a potential path forward. If Ms. Okonkwo were willing to acknowledge for the record that her bar admission had been procedurally irregular, not necessarily invalid, he was careful to say, not necessarily anything that reflected on her professional conduct, simply irregular in a way that would require a formal review period during which her license would be suspended pending reinstatement proceedings. If she were willing to acknowledge that, the board was prepared to treat the matter as resolved without further proceeding. He was offering her a deal. Adaz looked at him for a long moment. Then she said, no. If you've ever been in a room where someone with significantly less institutional power than the other people present says no when everyone expected yes. You know what the air does. It doesn't exactly change. It compresses, like the moment before weather. Whitmore said, I want to make sure you understand what you're declining. Adaz said, I understand exactly what I'm declining. He explained it again, more slowly. The suspension would be temporary. The reinstatement process was straightforward. Her professional record would remain largely intact. The alternative, proceeding to a full disbarment hearing, carried significantly greater risk. Did she understand that? She said she did. He asked if she had consulted with counsel. She said she was counsel. He paused at that. Then he asked if she wished to take a recess to reconsider. She said no. And here's the thing about that no. The thing that the people in that room did not understand yet, and that Whitmore would only understand later. Autumn, when he finally read the full file. The no was not stubbornness. It was not pride. It was not the emotional response of a woman who had been pushed too far and had stopped caring about consequences. It was a legal calculation, because Adaz knew something that Gerald Whitmore did not know she knew. She knew that 3 days earlier, in a federal court filing, the Flores versus DHS case had been decided. She knew that the decision had gone her way. She knew that the decision had gone her way so comprehensively, on the precise procedural grounds she had argued, using the precise precedents she had cited, in the precise sequence she had organized them, that the precedent it set was not just case relevant, but systemic. She knew that if she accepted the deal, if she acknowledged any procedural irregularity in her bar admission, that acknowledgement would be used in an appeal to argue that the Flora decision was tainted by the involvement of an improperly admitted attorney. She knew the case would be relitigated. She knew the people who had filed the complaint against her would use her signature on that deal as a lever to undo everything the decision had accomplished. She knew that if she signed, her clients won nothing. So she said no. And she sat in that hearing room for 4 more hours while Gerald Whitmore attempted, in increasingly frustrated increments, to understand why. Before I tell you what happened when he read the file, I need to tell you what the file actually was. Because it wasn't just documentation of her visa status. It wasn't just the record of her bar admission. It wasn't even just the Flores decision. The 17-page document Adiz had spent 14 months preparing was something else entirely. It was a reconstruction, a forensic accounting of the complaint against her. Not just what the complaint said, but where the complaint had come from. Who had filed it? When the decision to file it had been made. What the connection was between the anonymous complainant and the parties opposing her in Flores. What the procedural record of the hearing itself revealed about the information Whitmore had been given before she walked into that room. She had documents. She had email chains obtained through a public records request she had filed 11 months earlier, not knowing exactly what she was looking for, knowing only that she needed to look. She had the dated testimony of a former paralegal at the firm opposing her in Flores, who had given a sworn statement, voluntarily without subpoena, that she had been present in a meeting where the complaint against Adasi was discussed not as a legal concern, but as a strategic one. She had a communication between 2 partners at that firm and a member of the Bar Association's administrative staff, sent 6 weeks before the complaint was officially filed, that referred to the Okonkwo situation in terms that had nothing to do with her visa and everything to do with Flores. She had, in other words, evidence of a conspiracy to disbar her, not because of what she had done, but because of what she was about to win. And she had put all of it, every piece of it, organized with the precision of someone who had spent years reconstructing the legal architecture of other people's cases, into a 17-page document that she had not submitted into evidence. She had not submitted it because she was not using it as evidence. She was using it as a mirror. She wanted Gerald Whitmore to read it and see himself in it. Not as a villain, not as a corrupt man, as a man who had been handed a version of events, had accepted it, and had not asked whether the version was complete. She wanted him to understand what he had been used for, because she needed him to do something that no institutional proceeding was going to force him to do. She needed him to make a choice. It was late afternoon when Whitmore called a recess. He came back 20 minutes later. And he asked Adad if she had additional material she wished to submit. She said yes. She submitted the document. She sat down. She waited. If you're watching this and you've ever had a moment in your life where you knew that the truth was on your side, but couldn't control whether the truth was going to matter, I want you to tell me that in the comments below this video. Because what Adas did in that room, sitting with 17 pages of proof and waiting for another person to choose to see it, is one of the hardest things I've ever come across in any story I've told. You can know the truth. You can document the truth. You can present the truth. And then you have to sit in a chair and wait for a human being to decide whether the truth is going to mean anything. And you can't control that. All you can control is the quality of what you've prepared. So if you've ever been in that chair, if you know what it costs to wait in that chair, tell me below, because Adoz was not alone in that experience. And I don't want her to feel like she was. Gerald Whitmore read the document in his office. His clerk would later say that he read it once quickly, then set it down, then read it again slowly. That the second reading took almost 40 minutes. That he did not make any phone calls during that time. That when he emerged, he did not look like a man who had received bad news. He looked like a man who had received an accurate picture of a situation he had previously been seeing through a distorted lens, and who was in the process of deciding what a person does when that happens. He called the hearing back into session. He looked at Adais. He said, "I owe you an apology." The room went quiet in a way that rooms rarely go quiet. Not the quiet of people being polite, the quiet of people recalibrating. Whitmore did not elaborate immediately. He had the document in front of him. He said that having reviewed the materials submitted by Ms. Okonkwo in their entirety, he had significant concerns. Those were his exact words, significant concerns, about the procedural integrity of the complaint process that had led to this hearing. He said he was placing the hearing in abeyance pending a full review of the complaint's origins. He said he was referring the matter voluntarily to the State Attorney General's office for review of potential interference with bar proceedings. He said he was notifying the Bar Association's Ethics Board that a member of its administrative staff had potentially been in contact with adverse parties in a case connected to the respondent. And then he said something that was not in any procedural handbook. He said, "Ms. Okonkwo, this hearing should not have happened. The case you have been defending should have been the only proceeding with your name on it in the last 14 months. The fact that it wasn't is a failure of this process that I did not cause, but that I participated in without sufficient scrutiny. I'm sorry for that." Adise looked at him. She said, "I know." She said it without anger. She said it without satisfaction. She said it the way you say something to someone when you have known it for a long time, and saying it out loud is not release, and it's just acknowledgement. Then she said, "The floor's decision was handed down on Friday. I have a copy if you'd like to read it." Whitmore took the copy. He read the first page. He set it down. He said very quietly, "You'd already won." She said, "3 days ago." He said, "And you sat here all day knowing that." She said, "I sat here all day because the win doesn't mean anything if the process that produced it gets contaminated by whatever I would have signed this morning." Whitmore looked at her for a long time. Then he said something that was not recorded in the transcript because the court reporter had stepped out during the recess and had not yet returned. His clerk remembered it. Adise repeated it in an interview 2 years later. He said, "You understood the architecture of this better than I did. And I'm the one who's supposed to." Here is what happened after. The complaint was investigated. The former paralegal's sworn statement held up. The email chain was authenticated. 2 partners at the opposing firm faced bar complaints of their own. Complaints that were not anonymous and were not resolved quietly. The administrative staff member resigned. The investigation found definitively that the complaint against Adise had been filed as a litigation tactic, that it had been coordinated with parties adverse to her client, and that it had been improperly expedited within the Bar Association's review process. Adise's bar license was never suspended. The disbarment proceeding was dismissed. The floor's decision stood. The precedent it set affected the deportation proceedings of thousands of people across 4 states. It was cited in 17 subsequent cases in the 2 years after it was handed down. It is still being cited. Her client, the man at the center of Flores versus DHS, a man named Santiago, who had lived in Columbus for 19 years and whose children had never lived anywhere else, was not deported. He is still there. His youngest daughter graduated from high school in June. Adaze was at the graduation. Now let me tell you what this cost her, because I promised you I would, and because the story is incomplete without it. The 14 months of the investigation were not survivable on her regular caseload. She could not take new clients at the rate she had been. She could not appear in certain proceedings while the complaint was active. She lost income. She lost 4 clients who, not through any fault of their own, could not wait for her situation to be resolved and needed representation she could not currently guarantee. One of those 4 clients was deported. Adiz does not talk about this person by name. She's been asked about it in interviews and she gives the same answer every time. She says, "There was someone I couldn't help because I was occupied defending my right to help people. I think about that every day. I don't think I'm supposed to stop thinking about it." She rebuilt her practice. It took almost 2 years to return to the caseload she had been carrying before. She is carrying a larger one now. She hired 2 associates. She started a pro bono clinic specifically for immigration attorneys facing professionally retaliatory complaints. Because she had, through her own case, become the leading expert in the country on exactly how that process works and exactly how to fight it. She turned the machinery that was used against her into a workshop where she teaches other people to dismantle it. And Gerald Whitmore. He submitted his resignation from the Board of Professional Conduct 6 weeks after the hearing, not because he was asked to, not because the investigation implicated him. It didn't. He had been used, not complicit. He resigned because, in his own words, in a letter he sent to the Bar Association and later made public, he could no longer in good conscience occupy a position he had held for 11 years without examining whether that position had been at any point a conduit for exactly the kind of pressure Adiz's case had exposed. He said he needed to understand what he had been part of before he could continue being part of anything. He spent a year. He did his own reconstruction, his own accounting. He looked at 11 years of cases and asked the question Adiz's document had forced him to ask: who had given him context, and what had that context been designed to produce? He found things. He reported them. To the Ethics Board, to the Attorney General, to the state legislature's Judiciary Committee. Some of what he found resulted in formal proceedings. Some of it resulted in policy changes. None of it was comfortable. None of it made him a hero in the circles where he had spent his career. He and Adiz have spoken twice since the hearing. The first time was a phone call she initiated shortly after his letter became public. She called to say that what he had done took integrity and that she recognized it as such. He said he was not sure he deserved recognition for doing what was simply correct. She said she knew the difference between someone who does what's correct when it's easy and someone who does it when it costs something, and that she was calling about the second kind. The second conversation was a meeting at her clinic where he spoke to a room of junior attorneys about what it looks like when a proceeding has been shaped by external pressure before it begins, and how to recognize the signs from the inside. He was, in her words, one of the most useful speakers they had ever had, because he knew the machinery from the other side. This is the part where I want to be precise about something, because stories like this one can travel in a direction that flattens them into something simpler than they are. Adiz did not win because she was exceptional. She won because she was prepared. The distinction matters enormously. Exceptional is something you either are or you're not. Prepared is something you do. She had spent 14 months building a document while also working a 60-hour week, while also managing the anxiety of a proceeding whose outcome could end her career, while also carrying the weight of clients whose cases could not wait for her situation to resolve itself. She did not build that document because she was superhuman. She built it because she understood that the most powerful thing she possessed in that room was not her emotion or her credentials or her indignation at what was being done to her. It was the quality of her preparation. And preparation, unlike genius, is available. This is also not a story about a good judge and a bad system. Whitmore was not the villain. The people who fed him a version of events were not even the deepest part of the problem. The deepest part of the problem was a structure that allowed coordinated interference with professional proceedings to operate in the space between what was documented and what was visible. A Daisy's document didn't destroy a villain. It made something visible that had been operating in darkness. And the visibility changed what the people who encountered it were able to do next. That's not a fairy tale ending. That's a structural one. And structural change is slower, less satisfying, and more durable than the fairy tale. A Daisy would tell you that. If you want to know what she's doing right now, the answer is the same thing she's always been doing. She's working. She took a case last month involving a family in Toledo whose asylum claim was denied on a procedural technicality so narrow that it required an expert in the specific administrative law subsection to recognize it as the error it was. She is that expert. She is building the appeal. The family does not yet know they are in very good hands. They will. If this story moves something in you, if what a Daisy built in that room made you think about the kind of preparation that changes outcomes, about the difference between surviving a system and understanding it well enough to expose it, I want you to subscribe to this channel, because this is what we do here. And we find the stories where ordinary people, prepared people, specific people with names and costs and something to lose, made decisions that were not simple. We tell those stories completely. We don't flatten them. We don't skip the cost. We don't pretend the ending resolved everything. We trust you to hold the complexity. If that's the kind of storytelling you're looking for, the subscribe button is right there. And I'd genuinely love for you to be here for the next one. The last thing I want to tell you is about the email, because I know you've been waiting for it. I know the title promised you the email, and I have been telling you everything around the email for 20-some minutes, and you deserve to know what it said. Adais sent the email to Professor. I'm not going to use his name, honored because this story is not about him in the way he would prefer. On a Tuesday afternoon, the subject line was 4 words. It was, I believe you've already read this. The body of the email was 3 sentences. She wrote, attached is chapter 4 of my thesis, submitted to your department on March 14th. Attached also is pages 34 through 51 of your published paper in the Journal of Migration Law, published September of the following year. I have CC'd the thesis committee, the department chair, and the university's academic integrity office, and I will be available to discuss the attached materials at their earliest convenience. That was it. No accusation, no anger, no demand. Just 2 documents placed beside each other with the implied request that someone look at them and say what they saw. He resigned the following morning. For he did not contest the plagiarism finding. He did not appeal the university's decision. He submitted a letter of resignation that did not mention Adesi by name, but acknowledged, in the careful language of a man who had been shown what could not be unseen, that he had made professional errors of significant magnitude. The D was struck from Adesi's record. Her thesis chapter was submitted to the Journal of Migration Law. It was accepted. It was published. It has been cited 31 times, including twice by courts ruling on immigration cases, including, if you want to feel the full weight of this, once in the footnotes of a decision adjacent to Flores versus DHS. The work she did became part of the legal architecture, not because of who she was, because of what she built, because she documented everything, organized everything. Hanfa let the evidence speak before she said a single word, and understood that the most powerful argument is the one that does not need her to be angry for it to be true. Do not let them make you small by degrees. Her mother wrote that on a piece of paper in an airport in Lagos. Adis carried it for years before she translated it. I think she understood it before she translated it. I think she understood it every time she sat down to build something they hadn't seen coming yet. If this is the kind of story that needs to be heard by someone you know, someone who is in the middle of a fight that feels impossible, someone who is preparing something that no one around them can see the point of yet, with someone who needs to know that preparation is not the consolation prize for people who don't have power, but the specific mechanism by which power gets redistributed. Send this to them. Right now. Don't wait. Just send it. And if you want to stay, if you want to be here for the next story, the next video is about a man who was given 60 seconds to speak at a hearing that would determine the futures of 400 people, and what he chose to say with those 60 seconds. It is sitting right there. I'll see you in it.